that if the committee decides it's constitutional, we'll send it back to the President. Parliament cannot abdicate its role. But let's say, even though we think it's constitutional, we go the way you two advocates are suggesting. The way you put it, one of you said it, what? Why have a fight if you can meet it in words? I think it was yourself who said that. I agree. So then, even though we agree it's constitutional, we can tighten it to make it better and to address some of the concerns of people here. Then the second thing I wanted to ask you, can we say very clearly, although this is implied, that the inspectors can only inspect in terms of the Act, right, Advocate Semenya? In the Act. And as I understand it, unless I'm wrong, and that's why the FIC and National Chief is coming, they can't do anything else but refer it to the SAPS. Is that correct? Then you don't even have the power to ask the SAPS to do what you're asking them to pursue. Is that correct? Right. Now the question is, can we put in a provision here to cover some of the concerns that says that something like the inspectors must work, I'm thinking of a crude way of putting it, right? The inspectors must work cooperatively with the SAPS and security cluster in a way that acknowledges that criminal prosecution is a function of the criminal justice. Why are you laughing, Makosi? I'm trying to help. Needling you. Or Tandi needles everybody, me the most, right? No, I agree with you. Makosi, I've been here for 2.5 years. Tandi, you are guilty unless, I'm sorry, in this case, advocates, I'm not interested in your opinion. You are guilty for heckling and harassing people unless proven otherwise, right? Now, finally, I want to say, can we address the concerns of the BBC and maybe others here, civil society, that actually we make it clear that the FIC inspectors must work with the security. And if you're saying that's what happens, let's put it in the bill. What would be a problem with that? Would 79(1) preclude that? Okay. Having said that, Floyd.
Thanks, Chair. So when the meeting started, the lawyer from Parliament explained the scope of this meeting. And I deliberately asked him to repeat what he said, that this process that we're engaging in now is going to deal with the reservations of the President in relation to the Act. In order to avoid discussion, there was a process of engaging in law. It was a public hearing process that was engaged in. People made submissions. We clarified this over a long period of time. Put the bill in Parliament, was passed, was taken to the President. Yes, but a concern about warrantless searches. And that is what he has brought the law back for. And that is what we must deal with. So this win-win discussion that you're having with yourself now is not helping us with anything. If you think that there are other issues, maybe you must write a separate process. But this process that we're engaged in now is ring-fenced in the Constitution, that we are dealing specifically with the issues that the President has raised reservations on. It's not only the lawyer from Parliament who has said that. Two advocates, senior counsel, affirm that principle that we might wish to look into other issues, but we're dealing with that aspect which the President has raised reservations on. If maybe the President gets a new instruction from whoever instructs him that he must object again, you can do so. You can write back to us and say, no, I thought it was only the warrantless searches only which were concerning me. I think that we must look into this other aspect as well. And then we can look into it until everyone else is satisfied with the whole process. But please don't conflict this process. We deliberately asked when we started, what are we dealing with here? And now, you're catching fire because people have spoken and everybody must not be other things. Please, let's remain focused.
We will stick within the law. Can I clarify my questions? We will stick perfectly within the law and the rules of Parliament. The emails I have sent you, Floyd, which I presume you haven't read, Mr. Shivambo, if you're listening at all. Floyd, you made your point, right? Floyd, can you stop heckling Celono, whom you claim you don't know? Now suddenly you are buddies. Right. Now, the point I want to make is, Floyd, listen to this. You probably didn't read the email exchanges. No, I'm not blaming you. and you probably didn't see the advert. The advert's very clear. I have no choice as a chair. It's not my subjective decision. We have to abide by the rules. But within the rules, they are both here. We're asking what is within the rules, what is possible, not outside it. Thank you. That's what I'm trying to say, but we'll get replies from them. So it was Makosi, it was what's his name, Pule, and then Thandi. Thank you.
No, Chair, thanks. I think you have to some extent clarified some of the things, because when things are referred back to us to try and consider a number of things, including what has been raised now of warrantless searches, and where we have invited other stakeholders like organizations that are in business and will be affected by some of the things, I do not think that they are actually, we should bar them from bringing forward issues that they feel are also of concern. Of course, in terms of how you process that, you are not going to necessarily undermine the rules of Parliament. You are going to do everything within the confines of the rules. So that is critical. But I think it's very mischievous, to suggest that if the president of the ANC in the country goes out somewhere and gets to be told something, then will bring something new. I think that undermines the integrity of the person of the president. Because what has been brought before us is something that would have even required your senior counsels to provide different opinions and all of that, so that we take this in good faith, and ourselves as members of Parliament try and put in that process in a manner that we find a solution, one that is working and building for the country, but also be able to consider the concerns that could also be coming from stakeholders, especially the business community and civil society, who might have certain concerns. I mean, if we want to be a truly participatory democracy, we must be able to listen to different views. That's the only way that our democracy will become a shining example to many others in Africa and all over the world. Thanks, Chair. I just felt we must just deal with that, because if we don't, an impression will be created that we, the ANC, the party I represent, by the way, here in Parliament, gets mandate elsewhere and then bring it to Parliament. It doesn't work like that. We engage, and we feel that things must be referred back for further consideration. They are brought back in that way. So we should at least be respected. After all, we are still the leader of this country and this government. Thanks, Chair.
You and Floyd are from the same youth league, right? Same age. Can you all have tea together and sort it out? I have Floyd, you know what? You'll get a chance to reply. But at the end of the day, it doesn't really matter where it comes from. We're looking at the merits or demerits of the issue. Now, can we move on, please? Makosi. Or why don't you speak first so Makosi can slam you? Yeah, let him speak, then you can slam him. This is Parliament for you. Partly, you don't want to slam him. Okay.
I just want to make a special appeal. Notwithstanding the constraints we have in terms of the rules, what we need to address, and so forth, we have members of the public here who are still going to be making their presentations. Let's not restrict them. Let them present whatever they make, whatever submissions that they have, and then as the committee, we will then reflect within the rules of Parliament. Let's not superimpose the rules before they even make their own presentations. I don't think it's a fair way of doing our business. Let's allow them, and I think we should proceed. And your questions, Chair, were relevant.
Funny, but fine, that wasn't you, it was Thandi, right? Thandi has a right to speak, and then so has Floyd. I have no choice, the rules dictate. I'm a victim of rules here. Who thinks the chair has any power? I don't. I'm not in this circumstance. Over to you. It's wasting a lot of time. Come on, let's move, please. Thandi, what is it? Fine. Yeah.
The first one is, let's proceed. The second one, it's fun to play different planning discussion. It's typical young age, it's fun. But the basic principle, you said it when you opened the meeting, it's to allow dialogue. And here, we're dealing with a very sensitive issue where we want to address misconceptions about the interpretation of the law. It's not an easy matter. It's a matter where, when you leave this house, we're at least one in terms of understanding. And one of the basic issues is to understand that Parliament belongs to the people. So at some point, we'll give latitude for certain types of engagement that might not necessarily be the statutes of the law. So in this context, I am trying to bring Pule and Freud close together to understand, because I'm a generation above them, so I'm trying to bring this together. So,
you're 6 months older than that, please. Now, Tandi.
Can we proceed? Can we please proceed?
Yeah, fine. We heard you.
Floyd,
Yeah.
bring the flag in.
Yeah, okay. Floyd, you got 12 seconds.
Chairperson, I suspect there's no coherence, maybe organizationally from the ruling party, because I remind you when we were debating the FSR bill, according to the fact which is relatively going to check, I thought when the NEC and Mr. Mab, the NEC, the ANC took a resolution that this bill must be signed into law as a matter of urgency, and the Secretary General of the ANC did public communication about it. And I pointed to the fact that the parliamentary majority of the ANC here in Parliament passed the bill with the intention that it must be signed into law. The National Executive Committee had the same agreement, and then a president got instruction from elsewhere, I don't know whether it is, to then bring it back, and that is the point we changed. The integrity of the president can be questioned because he likes it and must speak about it openly. No question about that. It's not outside the rules of parliament to say that.
Okay, we've discussed that. All right, fine. You said it in the House and we couldn't stop you from saying it. Right, we've heard you before, nothing new, nothing. Listen, I don't have more powers than the Speaker of this Parliament. Can the comrades realize this? I have no more power. He said all these things in the public domain. He was not ruled out of order. It was I who had to respond to some of those issues. So please, don't waste my time. Go and change the rules, please. Is there anything I can stop him from saying there? Right. Can you speak, please? Now speak in the mic, please. Into the mic. Please, don't waste my time. Please, comrades, you are experienced enough now. And can we improve the mic, the roving mic, can we sort it out, please, Teboro? Oh, he doesn't know how to use it, yeah.
Interpretation of the rules, correct.
I can do nothing, right? Now, if you want to challenge in the court of law, can we move on? I'm not allowed to make discussion on this, unless it's from an advocate or a lawyer. No. I cannot do anything outside the rules. Here's the rules. Right, fine. Now, having said that, can you reply, please?
Mr. Chair, my learned leader has asked me to deal with these questions. Can we begin, because it may constrain the debate, could we begin with the ambit of these proceedings? And the ambit, Mr. Chair, is made clear by what Mr. Jenkins told the committee this morning, but could I just repeat it for a moment, because it is important. Section 79 of the Constitution makes clear that the reconsideration must take place in accordance with the joint rules of Parliament. The joint rules then deal with this expressly. Firstly, in Rule 203 sub 2a, which says the committee must consider and confine itself to the President's reservations. And then similarly, Rule 204 2a, which says that the debate in the Assembly must be confined to the President's reservations. So even once this committee is decided, it's confined. We would respectfully submit that that answers the question, that as a matter of law, all that this committee can do is confine itself to the President's reservations. That leads to the second question that you raised, Mr. Chair, which is, would it be open for the President to now raise new reservations when it gets sent back to him? And our submission is that the answer is no, it would not, for two reasons. Firstly, because Section 79 of the Constitution makes that clear. 79.1 says the President, if he has reservations, must refer this back to the National Assembly. That's what he's done. And 79.4 then says, if after reconsideration a bill fully accommodates the President's reservations, the President must assent to and sign the bill. In other words, the only question that the President will ask when the bill goes back is, has this accommodated my reservations? What reservations? The ones I referred to Parliament under 79(1). So it's clear that the President has one opportunity to raise constitutional reservations in relation to the bill, not an ongoing process. And
what if he wrote to us tomorrow, before we finalize this process? Can he do that?
That is not contemplated by Section 79 of the Constitution. It contemplates the President making one decision, referring back, which he has now done, this committee and the National Assembly, and then making another decision and sending it back to the President, and the President just re-looking at his initial reservations. But could I make one other point, Mr. Chair? My understanding is that the concerns about Chapter 11 of the Constitution were raised with the President, and that he decided not to refer those. I speak under correction, but that's my understanding. That would be a further indication that he decided not to refer them to Parliament, and therefore that it cannot be done now. So that, Mr. Chair, goes to the process and where we are. Could I then come, Mr. Chair, to the question that was raised both by the members of the public but also by yourself about the interaction between the SAPS and the Fic. And it seems to me, Mr. Chair, that there's an important provision which must not be overlooked. And that is a provision which is introduced by Clause 1 of the bill. Clause 1M introduces a new definition into the Act, and it's a definition of non-compliance. Now, can I just pause? You will recall, Mr. Chair, that the only purpose for which entry or searches can take place under this provision that we're debating at the moment is for purposes of determining compliance with the Act. That's what it says. So, and how we've interpreted it. Now, non-compliance is defined in the Act by means of that clause, which I'm about to read you. It says, non-compliance means any act or omission that constitutes a failure to comply with a provision of this Act or any order, determination, or directive in terms of this Act, and which does not comply, which does not constitute an offence in terms of this Act. In other words, when the inspectors from Fic are to enter the premises, they may only do so for purposes of checking whether there is compliance with the Act, and compliance is specifically defined as excluding offences. So there is no danger with respect, Mr. Chair, either at the level of policy or at the level of Chapter 11 of the Constitution, that the Fic inspectors are usurping the power to investigate or prosecute offences, because at least under this section, because their power is limited to doing so for things that are not going to constitute offences. And that, with respect, Mr. Chair, is the answer to the point that was raised by the various civil society organisations when you gave them the opportunity. There are many things, Mr. Chair, that are both offences and a regulatory problem. I go back to the Estate Agents Board. It is an offence to do certain things as an estate agent without a licence, but it also violates the Act and can produce civil liability. The point is that one often has these inspectors to deal with regulatory non-compliance, and if there are then offences, that will be dealt with by the security services. This bill in our submission respects that divide, and that definition which I've pointed to you, Mr. Chair, demonstrates that that is the case. And then lastly, Mr. Chair, you did make the point, and you asked us to confirm that it was our understanding. You asked if we were making the point that if this provision was problematic, the Constitutional Court would have said so on the basis of Chapter 11. We respectfully agree entirely. The Estate Agents Board case concerned two provisions. A provision of the Estate Agents Act, which gave Estate Agents Board people the power to inspect, and this very provision of FICA, which gave FICA inspectors the power to inspect. If the Constitutional Court had thought that those were inherently unconstitutional, it wouldn't have tinkered and read in and tweaked and balanced. It would have said, this is inherently unconstitutional, and it didn't do so. And I think that has answered all of the points that have been raised, Mr. Chair.
Advocate Gordon. Thank you, Chair. Chair, fortunately, the clarity and amplitude in which my colleague has answered your questions means that I can just zoom in, if I may, on three aspects. For the avoidance of doubt, let me say that, as is implicit in what I've just said, I believe that what he says is entirely accurate as a statement of law and is not to be improved upon. Essentially, what is to be lifted out is this. One is the thrust of your questions to us, as I detected, is to probe how it could sensibly be the scheme under the Constitution that the President, playing this important role that he has, so he's not just a rubber stamper of legislation, he can raise a flag with his hand, but he can't himself take a pen and change. He's got to send it back and say, these are concerns.
Parliament then decides that. The third step, as our colleague has said, is that the President has to look at that response and then decide if the President wishes, as it were, to push the relatively nuclear button of going to court on the issue, or whether his advice, his assessment, is that the concerns are addressed or substantially addressed. It doesn't contemplate, and I reiterate, any form of ping-pong. That is so functionally, sensibly on the Constitution. It also doesn't mean that, although, and the important point has been made, that this body above all bodies would wish to be receptive to a wide variety of opinions, that it is permitted by this scheme to lose its focus on the fact that it is the President in his particular constitutional role as flagman, linesman, wicketkeeper, call it what you will, but to raise an issue that others can say, oh, by the way, at the same time, I've got another 14 points. I didn't like what you've legislated thus far, or 6 points, or 3 points. There has been your process to date. It can't be expunged by recourse to unwinding what you have done. What's left in place is, on the scheme of the Constitution, one flagman, one linesman with this particular capacity. Again, as I say, not himself to step forward, kick the ball or pick up the pen, but to say, please consider. So it's vital that one assesses and interprets that scheme correctly, because otherwise, with great respect, this body would go off the rails. If what it's doing effectively becomes a second guessing, a revisiting of all that it has done up to now in the legislative process. Secondly, that is so as a matter of wording, and my learned friend Mr. Budlander took you to the wording of section 1791 and 1792, which makes it clear, and you always know that lawyers are going to be expensive when they start to speak in Latin, but that the President, qua his reference function, in relation to his reference function, is functus officio. He's done the job. He's done it, and then what happens is the next mechanism back